kick in the chair and then we'll,
These are
that's good news. Well, welcome back, everyone. We're continuing our work this afternoon in House Gov.Ops and Military Affairs, picking up with a look at the Senate proposal of amendment to H305. And Deputy Secretary Andrew, thanks for being with us.
Thank you so much for the opportunity to speak with you this afternoon. For the record, my name is Lauren Hibbert. I am the Deputy Secretary of State. The Senate amendment to H305 has a policy component and a fee component, which these are also policy. So I'm happy to speak to one before the other. Do you have a preference on the order?
Why don't we talk about the policy changes, talk about the fees, and then hopefully Mr. Devlin will be back if we have questions about the policy pieces, which I think were his scope, and Ms. Wasserman was the fees pieces, if I'm understanding that correctly.
Happy to do that. Okay, so the first big section of changes is related to pharmacy. We were able to work with stakeholders after the bill left the House side to make some amendments to the policy sections, some of which were active issues when the bill was pending in front of your committee, but active but unresolved, and some really needed clarification. It came to light after the bill had left your committee. The first significant amendment allows for pharmacists and pharmacy technicians to provide the flu vaccine and the COVID vaccine or subsequent formulations or combination products. So we're anticipating that at some point there'll be a combination shot for flu and COVID for patients who are 5 and older. Just to remind everybody, since you may not be in the world of childhood vaccines every day, childhood vaccines have typically always happened in a pediatrician's office. This is allowing the pharmacist or the pharmacy technician to provide the COVID vaccine and the flu vaccine. Anecdotally, this has been very effective at getting children vaccinated because of the delays in getting your child into the pediatrician's office. It's very convenient for families to go to their local pharmacy to get the delivery of these vaccinations. These vaccinations still would obviously need parental consent and also would be entered into the vaccine registries. Sometimes people are concerned that children will get double vaccines, but that is extremely unlikely because first, parental consent, and second, vaccine registry. So the record of vaccination would be available to anyone who is doing a subsequent review of the vaccination history or if that child should be vaccinated.
Representative Pango has a quick question.
Thank you. Quick question. Currently, what is the age that a child can be given an immunization at the pharmacy?
Currently, it is 2 because of the PrEP Act, the federal PrEP Act, which has been allowing pharmacists and pharmacy technicians to provide these vaccinations plus others to children. That those provisions are expiring or may have expired. I think they're expiring this week.
So that was the temporary COVID era.
That was the temporary COVID era.
And prior to that, then what is regular practice?
It was 18. So this is a carve out from the 18.
Okay, thank you.
I will just say that we haven't seen issues with children being vaccinated in pharmacies, even with the more expanded. But this was an area of compromise between the pharmacists and the medical society, one of those great cafeteria talks. So this was the agreement.
Do you want a conversation on this piece or do you wait to the end?
Are you done with your testimony on this particular section around the vaccines? I just want
Yes.
Okay. So yeah, let's go ahead and ask questions about this section before we get something.
This isn't so much a question, but I think, we've been getting a lot of emails and that's what it's been around. And I certainly have an objection to it as well. I think, kids as young as 5 should have their shots and immunization, whatever it might be, combination thereof, provided by and in the presence of their pediatrician. So that's just where I'm coming from, and I believe so many folks that have and emailing us feel the same way.
If I could just have the opportunity to respond to that, I think it's really up to the choice of the parents. And if the parents feel comfortable with their child being vaccinated in the pharmacy 5 and up, then this would allow them to have that option. I think a lot of parents will choose to continue to go to the pediatric home for a variety of other reasons, because it's the well-child visit, or because they have another concern, or because their child is someone who may not like shots, right? And may not be someone who is a good candidate to do it in a pharmacy. I can speak just as a parent myself. I have a 10-year-old and a 13-year-old, soon to be 14-year-old. They both have no fear of needles. In fact, are kind of fascinated by them, which is a whole other topic. They would be great candidates to have it done in the pharmacy, because they wouldn't be scared. They would be totally capable of doing that. And it is hard to get into your pediatrician. So I may be a parent who would choose to do that, but another parent may not. And I think that's the key to me, is the parent needs to look at their specific child and make the determination for their child.
So nationally speaking, institutes of health, you said that we have not seen anything. Is there a national statistic that says that kids that young are not experiencing rejection or reaction?
Overall, there's not a notable reaction to the COVID vaccine or the flu vaccine for children that are 5 and up. In terms of rejection so that's reaction. In terms of rejection of the shot, I haven't seen any data on that. I will say that there are many other states, even pre-COVID, that did allow for vaccination of children in pharmacies. Vermont was not one of those states.
So we're considering it safe.
I believe it is safe, yes.
Representative.
Could you talk a little bit more about conversations with do you see the medical folks or pediatricians or?
Yes, so I talked with the medical society, the Vermont Medical Society, and with the Vermont Pharmacists Association, and with the retail drug outlet. So it was a multi-stakeholder engagement. And the tension really is, when should a child be seen by a pediatrician versus when is this more sort of like an errand that needs to be checked off for parents? I think there's broad consensus that children need to see their pediatrician regularly, yearly, if there's a major concern. The crush around the fall vaccination schedules, this is mitigating that. And so I think this is a good compromise for all of those stakeholders. And I think the stakeholders all were in agreement with this compromise.
Any further questions about the vaccination scope? Representative.
Just one quick question, just to reiterate, you said that this is entirely voluntary. I mean, a parent could go to their pediatrician should they choose. So this is a parent's choice to be able to go to a pharmacy.
Absolutely, yes. And that parent would be signing a consent form for the treatment. So informed, voluntary, and pediatricians are always going to be available for children for vaccination.
Thank you.
The second pharmacy-related amendment was related to COVID testing. Again, COVID testing has been happening since the beginning of our COVID times, and it allows for that if a pharmacist is doing COVID testing and the test incidentally detects flu or RSV, which the kits, I actually learned quite a bit about the science of COVID testing. So the swab, the nasal swab, gets put into what's called a kit. And the kit, the way they're being manufactured, provides results for these 3 diseases. And currently the pharmacist is only allowed to talk to the patient about COVID. So what this will allow the pharmacist to do is if the test kit incidentally detects flu or RSV, the pharmacist can advise the patient of the results and recommend that the patient seek further care from a healthcare provider. So the telling a patient that you have RSV is that in a way diagnosing RSV because of the test. And so this allows the pharmacist to have that conversation. I think this is good public health policy. If someone has RSV, they should know. If someone has the flu, they should know. And it appropriately helps the pharmacist know what to do, which is to bring the person to a medical provider. Any questions on that amendment?
Okay, we can keep going.
The third pharmacy amendment is it gives the board the authority to adopt rules to grant a pharmacy permission to appoint a pharmacy manager who's been licensed for less than a year. This was a topic that was discussed quite extensively in this committee and was pulled. Those conversations continued, and this was the agreement and comfort area. What this does is it gives the board the ability to do rulemaking around this topic and engage more with stakeholders. They may choose to allow it, they may choose to not allow it, they may choose to allow it with certain provisions, but this really allows for the conversation to continue.
Representative Tango.
Is there a particular document that we can reference where it's written, what she just said?
It's so we're looking at the Senate proposal amendments,
Yep,
page
looking
305.
at that.
And that is section, this is at the top of page 7, section 13, starts on the bottom of page 6.
Okay, I hadn't gone far enough, thank you. I think we skipped over mental health professional, and that's what threw me.
Oh, sorry, I grouped the pharmacy together.
Okay, great.
I'm looking at my notes on the amendment and not at the bills, I apologize.
Okay, so this is something I recall our committee really being opposed to, was this provision.
So if I could just respond, previously it allowed for a pharmacy manager to be licensed for less than a year. What this language does is more nuanced than that. It allows the board to adopt rules that would allow that. And the reason why is it looks and seems to me like there needs to be more conversation with the stakeholders. And this allows that conversation to happen. It still will need to be approved by the board and then also go through the rulemaking process, which is rigorous and does require legislative review. But the conversation was, it's more, I don't want to say it's more complicated, but there's pressures in each direction around this issue. And we thought that rulemaking would be a good way to resolve the pressures.
The testimony I remember hearing, Lauren, was something to the effect of there are some people that are right out of pharmacy school that would make excellent managers. And then there are other folks that really need to have more experience and training to do it. And so sort of having a hard and fast prohibition in statute, what you're saying is we'll adopt rules to determine how somebody who was licensed for less than a year would be managed.
To create a process where that could happen.
Does that address your concern, Representative?
It does, thank you.
Representative Chase.
And would that potentially include like veterans coming out of the service who are pharmacy techs but weren't licensed, perhaps creating a path for them to get a shorter waiting period?
Yeah, so I think what you're talking about is fast tracking of military experience, which we have a completely different process. For this, if someone was licensed as a pharmacist, they still have to be a licensed pharmacist to be a pharmacy manager. So as long as they meet the qualifications to be a pharmacist, regardless of where they were trained or how they got their training, if they are licensed as a pharmacist for under a year and it meets what the board adopts for rulemaking, then yes, that would work.
So it's not a case by case, it's
Well, in the context of this conversation, I've had the conversation of what the board would do in many directions. It could be a case by case with board approval, or it could be a blanket solution. And I think the board wants to hear from the stakeholders and should hear from the stakeholders before they decide what the rules should be. So I don't know what the final rule will be on this.
Sure. Thank you. Anything else on the pharmacy? Okay.
Okay. So going back a section, and I apologize that I did that, Representative, to art and music therapists. So we, on the Senate side, heard from art and music therapists who have been wanting to be licensed or certified. Our office has done 2 Sunrise reviews of art therapists, 1 of music therapists. We have recommended that they do have a certification issued by our office. Both of those reports were done right before COVID of 2020, and then our office's attention and bandwidth has just been non-existent. So what we are committing to is not the creation of a certification for either of these professionals in this bill, but what we're recommending is that there was a bill that was passed last year in 2022, Act 117, which was a mental health professional licensure study. And that study is due in the winter of 2024. And it is a top to bottom review of how we license mental health professionals. This will not be the first time, so I'm not breaking any news here. The way that we license mental health professionals in our state is very complicated. It's very cumbersome. It's hard for applicants to navigate. We want to take a look at this top to bottom to try and streamline it, to make it more efficient. We know that there's a workforce shortage of mental health professionals, and we want to be a state where people can easily, with the right qualifications, enter the mental health fields. So that is the goal of the study from our office's perspective. We see art therapists and music therapists as a piece of the puzzle. Music therapists really don't see themselves as mental health professionals. They see themselves as occupational health professionals. But we think it's still enough of a nexus and fit that we would like to come back in the winter of 2024 with a proposal for how to structure the mental health professions that includes art therapists and music therapists. So that's what we're doing here in this bill.
Thanks. Just a couple of questions. You said that music therapists think of themselves as occupational therapists. Do art therapists also think of themselves as occupational therapists?
No, they think of themselves as mental health.
Okay. And currently, occupational therapists are licensed, not certified, right?
Well, just to be really clear, they don't think of themselves as OTs, as occupational therapists. They think of themselves more adjacent. I should have been more clear. Adjacent to occupational therapists. They don't consider themselves to be occupational therapists, but they're more like that because they're working on life skills in a different way than an art therapist who sees themselves as a mental health therapist, which there's many, many different types.
So by adjacent, my question is, certification would be the first step in a process. Is an occupational therapist licensed or certified?
An occupational therapist is licensed.
Okay, so this is the first step in a licensure process. Being certified doesn't mean that they would be required to be licensed.
That's correct. A certification, so the way the law is designed in Vermont, a license means registered, certified, or licensed. So it's a little confusing, but that's the definition of license. And so a certification, and just to go back, a registration means it's mandatory. Everyone has to do it to be registered. Everyone who wants to do it has to be registered, but there's no qualifications. A certification is voluntary. If you want to say you're a certified Vermont dietitian's my favorite example. If you want to say you're a certified dietitian by the state of Vermont, you have to go through our process. You have to be certified by us, but it's voluntary. Anyone in Vermont can give you diet advice, but only certified dietitians can say they're certified dietitians by the state of Vermont. And then there's license, which means it's also qualification based, like the certification, but it's also mandatory. And the issue with art therapists and music therapists is we do not think that the public requires that the license is mandatory. Because a lot of people provide art therapy or music therapy, but would never meet the qualifications for an art therapist or music
I
therapist.
think that's where I was going in my questioning. Thank you.
Yes.
And again, just quickly, who initiated the sunrise review in these two cases?
The professionals themselves. The art therapist did it twice. The first time we said that we did not see a need for licensure. The second time we reviewed it, we did, and found it was certification. And then music therapists, they applied for a sunrise report once.
Thank you.
And I could forward this committee those reports if you're interested. But they also are on our website if folks are interested.
Any other questions about this piece? All right, let's keep going.
Okay. So fee adjustments, I'm forgetting at this point in the session, and you all may as well, whether I came in at all to talk about fees when they were in Ways and Means on the House side.
So this committee has only just taken some brief testimony from you way back, I think in January, about how if we wanted to have the fees keep up with the expenses, we would need to address that. But
Yep.
we have not heard testimony about this piece or
Okay.
what's done about it.
So the fee adjustments and amendments on the Senate side was due in large part to work on the House side. But the House side amendment from Ways and Means did not have a vehicle. And so we used the Senate and this bill as the vehicle for fee adjustments. Cognizant of time, I'll just say that, again, our fund is a special fund. So we do not receive any general fund allocation. We only, in terms of OPR, we only have license revenue. So we cannot offset our deficit with general fund money. And our fees have not been adjusted since 2019. Many of the fees have not been adjusted for significantly longer than that. We always try to have a fee bill every 3 years, but 19, we were supposed to have one in 22, but that was not feasible that year. So we knew in 21 and 22 that we would need a fee bill in 23 if we could not get one through in 22. The budget for OPR is now in the red by approximately 2.5 million. This will bring it closer to even, but still does not fix it. These fee adjustments are not the fix to our budget problem entirely. We used the cost of living adjustment, and if you have the opportunity, you should hear from Joint Fiscal on how the fees were calculated, but we looked at what the cost of living adjustment was since the last time the fee was adjusted. There are a couple of instances where we went below the cost of living adjustment because some of the fees have not been touched since 1997. So we were looking at a 68% increase, for instance. That would be untenable and not workable. So we went down from that adjustment. And so that was our methodology for OPR. We also are adjusting the corporation's fees in this amendment. And that is because although we are not running at a deficit in the Secretary of State fund, that is also a special fund and it carries the rest of our office's work. And we are looking at 4 IT builds in the next year and a half. So we know that we're going to draw down significantly our fund balance. And we know looking forward that we need to raise fees in corporations to cover those investments. I will say that in corporations, a lot of the fees have not been adjusted since 2005, I believe. So that, again, the same cost of living adjustment was used to decide what the fee should be. And in those fees, the increases really across the board, all of the increases are relatively nominal, or where they were not, we adjusted down.
Representative.
So this is not a question, this is sort of a commentary that I liked the beginning of this bill. I do not like when we have fee bills that are attached to decent bills. It's unfortunate that you had to attach the fee bill to this because it's not totally relevant because there are fees for boxers and all other kinds of professions. And I'm not really in favor of raising fees on anybody. And I understand that the pharmacists, which this bill was primarily talking about in the beginning, they were okay with the fee adjustments. So unfortunately, it's like a deal breaker for me that the fee bill part is in here. But I did want to comment on previous testimony. I looked back and the only testimony we had did not, from Ms. Hibbert, it does not include anything about fees. So I think this is the first time we're formally getting any testimony on fees.
Yeah, I think that jives with my earlier comment that I think she, in passing in her testimony, may have talked about the structural issues, but it was definitely nothing related to the specific bill. I just want to say in response that I agree with Representative Hango. It is really unfortunate that we have to put these fees on an OPR bill. And the reason we have to do that is that we have not had an administration that will hold to the every 3-year review of fees. That was long the practice of this body and previous administrations. And the idea that we just don't increase fees is, to me, fiscally irresponsible. I don't want to belabor that debate here because I think that Ways and Means has already taken a position on this, and it's outside of our jurisdiction. But since the topic came up, I agree too that it's unfortunate that it's here, but it's the responsible thing to do to make sure that we're doing inflationary increases in fees and taking a look at them at least every 3 years. And we haven't had support from that from our executive branch partners. And that's left our regulators, who we rely on, who businesses rely on, and the public relies on for safety and making sure that we have businesses able to get their registrations and filings done the way that they need to. We need to support that work, and the fees are how we support that work. And so I'm going to be voting yes on concurring, even though I don't think this is the way we should be doing this. We should be doing this through a regular every 3-year fee review process, and there's just been a break in that process under this administration that it's not the fault of anybody in this room. Are there any questions for Director Hibbert about the fee section? So committee, on H305, this bill is up for action, so we need to take a position on it. Before we do, are there any questions for Legislative Council or Director Hibbert? I would entertain a motion to ask the body to concur with the proposal of amendment to H305. So moved. Representative Byron moves that we concur in the Senate's proposal of amendment. Is there any further discussion? Representative Ricky?
Sorry, Representative Brannigan can't be here.
I was channeling her.
A fee is not a tax, and a tax is not a fee.
Very fair observation.
Maybe she'll speak up.
All right, seeing no further discussion, the clerk shall commence the, do you need a sheet? Let's take a minute on it.
You have official possession, right? So it's not a straw poll.
Oh, yeah, sorry about that. It is a straw poll. I'm losing my mind. It's been a busy day. All right, committee.
That's why you took me by surprise.
I don't know. I was off in another land. So my apologies. This is, let's all remember that as much as we've been doing great work in here, this is my first end of session as chair. So cut me a little slack. All right, so there's a motion on the table to concur. So all those in favors of concurring in the Senate proposal of amendment to H305, I'll show a raise of hands. Are you in on this, Representative Murphy? Okay. So I've got Representative Waters Evans digitally, 1, 2, 3, 4, 5, 6, 7, 8, 9. All those opposed? 3. So Representative Nugent, since you're our reporter, you can report to the body a straw poll of 9-3 to concur.
Thank you very much.
Thank you very much, Deputy Secretary Hibbert. I almost said director. It's really, I'm getting it. All right. So now for something completely different, Mr. Devlin, thanks for being with us.
Of course.
Since we have a tiny bit of time here, I thought it might be good for the committee to at least start our work and see if we're ready to complete our work on S-17. So just wanted to do a pass and see what the Senate did with our bill, their bill, which was our bill, which is their bill.
There was something in yesterday's calendar, the proposal to amend the Senate proposal, which is proposal to the House proposal of the Senate.
Oh, that was on S-100.
Yeah. We're concurring with the Senate. We're working our House clerk and Legislative Council this week is the big week. It's your time to shine. But Senate proposal of amendment to the House proposal of amendment is where we're at now, Representative Murphy. So Mr. Devlin, would you please tell us about that? I'll just call it the amendment to S-17.
Again, for the record, my name is Tim Devlin, Legislative Counsel. So let's see, I believe what is being shared with the committee, we don't have an official or unofficial version of this back. So you'll have in front of you the was passed out of Senate Gov.Ops, which was then passed by the entirety of the Senate with a correction of a typo. I just want to state for the record there that one of the sponsors, it's not Senator Sears, it was Senator Jones. I just want to point that out. There are 6 instances of amendment in this. The first one is regarding the transitionary period between sheriffs. This will narrow the scope of the transitionary report to really, that is when the outgoing sheriff will leave that written list of, in the previous iteration of the House, this committee put out, was to be a list of all anticipated disbursements and transition of assets. This narrows that to really that list will include only transfer of departmental assets and financial disbursements to a single source in aggregate greater than $10,000 anticipated to occur before the sheriff leaves office. So that narrows that. It also, that's just that first underlined sentence. Before, in this committee's version, there was essentially what could be an override or if there was a transition of asset or disbursement of assets that both of the assistant judges refused to sign off on, it would have gone to the sheriff's executive committee could have stepped in and then approved it in their stead. That is not the case here. It is, let's see, perhaps it's easiest to read it. Assistant judges shall consult with the director of sheriff's operations. That's that new position that will be created in this bill. When considering whether to co-sign any transfer of departmental assets or financial disbursements to a single source in aggregate greater than $10,000, an assistant judge the assistant judges shall not unreasonably refuse to co-sign any disbursements or transfer of sheriff's department assets. And I'd like to point out that there is no definition for what is unreasonably refusing to do so or stating a reasonable effort or reason to refuse to co-sign. If a court were to interpret this in the instance of a situation where it was being litigated, it'd probably look a lot like a reason that is not arbitrary and capricious. A rational reason must be put forward as to why you're not signing over, but not just because, essentially. I'll pause there. That's a summary of the substantive differences.
The committee, so we had in our version of the bill that the sheriff's executive committee could act as a backstop, but we didn't include anything to any standard of sort of reasonableness that the assistant judges had to adhere to. So the needing to be reasonable in their signing off during the interim period seems to me an improvement in favor of if there was ever an assistant judge who was just trying to stick it to the sheriff and not sign off on their payroll or something like that. But now the backstop being the director of sheriff's operations seems logical to me, but do folks have any thoughts or questions about that?
No, not on that piece. Again, though, in that section, though, it's different too, as far as the assistant judges shall consult with the director of sheriff's operations before their decision. So that's a change from what we had originally as well.
All right, so the next one.
The second instance of amendment has to do with the Sheriff's Department's compensations and benefits model policy. This language from the Senate will now have both the Department of Human Resources and the Vermont Criminal Justice Council approving the model policy, as well as making any future updates to it. Prior, in this committee, it was just the Vermont Criminal Justice Council that was signing off or really approving what DSAS, or the Department of State's Attorneys and Sheriffs, is bringing to them. Now it will be DSAS drafting it and then sending it to not only Vermont Criminal Justice Council, but also the Department of Human Resources for final approval. And then any future drafts would be those two entities. That is, Department of Human Resources and Vermont Criminal Justice Council together altering or updating that model policy.
I know that there was some concern when we passed our proposal of amendment to the Senate that the Criminal Justice Council wasn't really set up to think about some of the HR stuff that would have to go into that model policy. So it seems like having DHR brought into it is improving. Any questions on this section? All right.
And further down on page 3, I didn't mention this before, but this is another substantive change. This will add in, new subdivision D regarding use of, this is a timing aspect. I'm just going to read through it, I think, be the best way to summarize it. Notwithstanding 24 VSA 291 AC, which is Sheriff's Department's contracting. That's how they'll use that 5% administrative overhead fee. Prior to a Sheriff's Department adopting the Sheriff's Department's compensation benefits and model policy, the Sheriff's Department may use funds derived from contract administrative overhead fees to make supplemental salary payments to a sheriff of not more than 50% of the annual compensation for a sheriff, provided that a sheriff has been in office for at least 2 years, and to any employee of a sheriff's department or sheriff that has been in office less than 2 years of not more than 10% of the annual compensation for the employee. Funds derived from contract administrative overhead fees shall not be used for any other bonus or supplemental employment benefit payment. And this language may look familiar. It's what the Senate Appropriations Senate Appropriations Committee added to S-17 as it was originally going through the Senate.
So as soon as the sheriff's department adopts the model policy, then this restriction goes away and the model policy governs.
Yes. And if I'm understanding the timing here correctly, so the policy will be drafted by January 1st. There's still some question as to when it will be approved by the Department of Human Resources and Vermont Criminal Justice Council. Then in C, we have on or before July 1st, 2024 is when the departments must adopt that. And then notwithstanding, sorry, I'm just getting my statutory cross references a little mixed up here. So notwithstanding that new language regarding that 5% fee usage it's actually being codified, which will go into effect on January 1st. So what's to be codified will coincide with the ideally when the model policy will be set, then have to adopt it by July. And this will essentially say yes. Sorry, long way of answering your question. I believe you're correct in how you characterized it of once you're able to and do, the Sheriff's Department does adopt it, then model policy would hold at that point.
So a sheriff that has more than 2 years of service can pay themselves up to 50% more than the statutory minimum, which is in the mid-90s, thousands of dollars a year. But a sheriff with less than 2 years during this interim can only pay themselves the statutory amount.
Plus 10%.
Plus 10%.
Okay.
Plus they can give themselves a 10% bonus.
And then all other employees could get up to 10% as well.
And that is in effect from passage until the adoption of the model policy, which should be available by January 1st. So a department that is ready to adopt its version of the model policy and put it into place in their own office, we're really talking about a few months here where this restriction is in place. Okay. Just want to make sure I had my head wrapped around that. Any other questions about that section? That was an interesting way of covering the gap between passage and the model policies adopted. Representative Morgan.
Just at the very end, unless I missed that, catching it, Tim, it says funds derived at the end of that paragraph, D, funds derived from contract administrative overhead fees shall not be used for any other bonus or supplemental employment benefit payment. What is that address?
That catch-all language, I'm trying to remember exactly.
Is it talking about the, hate to pinpoint another agency, but there was a certain agency that gave out a good size amount of bonuses, which they justified, but is it getting towards that, if you know what I'm saying?
I'm sorry, no.
They gotta say this.
So there was, we talked about this at length. So there was an agency that had $400,000 in bonuses to 16 people. This basically would limit those bonuses to be no more than
that. What that's addressing. That's what I was driving at.
Yeah, I think that's what the Senate's getting at.
Okay.
Is you can give people up to 10%.
Again, it's 10%. Okay. All right. Thank you.
The third instance of amendment, now we're on page 4. This section is referencing the appointment of that new position of Director of Sheriff's Operations. As the House, or this committee's version had it, it was the Executive Director of DSAS, or in consultation with the Sheriff's Executive Committee that would appoint the Director of Sheriff's Operations. This removes that in consultation with the Sheriff's Executive Committee, leaving it only to be the executive director of DSAS who would make that appointment independent. Let's see. Then fourth instance of amendment. Sorry, this has to do with, sorry, one moment. I just froze up on me here. Sorry. The fourth instance of amendment will add back in language that was, taken out in the House, this committee's version, which had to do with the affirmative duty for a sheriff's department to provide certain deputies to provide, really actually just saying a sheriff shall provide law enforcement security services for county and state courthouses within that sheriff's county. This adds that back in under the sheriff's duties section. Versus just being in the contracting, that one reference to, that singular statewide contract for the provision of these services between the judiciary and county sheriffs.
Representative.
And could someone remind me, please, if there is funding for that? Can't remember where that landed.
So the funding is the money that was approved for the contracts, right? So the reason the sheriffs wanted us to have a report on this prior to this piece going into effect was the concern around the ability to have enough bodies to make sure in every single county they could meet this. And so that's part of why we had the report, and then this goes into effect. The way this is set up, this will go into effect next year, if I understand that correctly. But we're going to have to act on it, I think, in the BAA potentially, because it's a little bit of a tug of war. The judiciary, wants there to be a sheriff. They want the law enforcement officer at each courthouse. But we heard from the sheriffs that they don't know that they'll always be able to staff that position in every county. Some counties it's normal course of business. Other counties it's really tough. So, I know House Judiciary and the Senate, thought that making this mandate, it's like if we're giving you the increase in the hourly pay, the sheriff should be able to find and recruit that person. But I think what we need to do is make sure we're paying attention to both the court administrator and the sheriffs and take a look at this in January right when we get back, because this mandate it's not quite an unfunded mandate because there's money there to pay these folks. It's just that there might not necessarily be the labor force to do it in all the sheriff's offices. So yes, and that's the answer to that question. And the Senate feels really strongly that the sheriff's offices should find somebody and have contracts and be at that courthouse. So there's a certified law enforcement officer there. And I think that's the preference of the courts, but we'll have to keep our eye on whether it's actually possible for them to meet this requirement.
So while I still have the floor, I guess I'm going to say that concerns me a little bit because it is somewhat of an unfunded mandate. I think it's a good idea to uniformly have the same type of official or officer at each courthouse. But I am concerned about the funding for it.
Yeah, I would say the funding's available, not necessarily the logistics. It's the
finding of the personnel too. Anyway.
So many almost intractable problems in this bill.
The fifth instance of amendment, and this is on that same page, has to do with the Sheriff's Department reform report. And this will add to the entity's reporting. Let's see, on line 11, breaking to 12, will now be the Department of State's Attorneys and Sheriffs, as well as the Vermont Criminal Justice Report. So those two entities working in tandem in consultation with those other entities, which remain the same, to produce the Sheriff's Department reform report. So, and that's really the only change there. just moving them from BCJC, that is, from the consulted list to the actually must report with DSAS.
Still a report, not a task force. Very pleased to see that. There was a lot of conversation between me and members of Senate Gov.Ops about how important it was to have a task force set up for this at this point in the conversation. I think this committee took the position that it should be a report back. Anybody have any strong feelings about Criminal Justice Council being tied on with SAS? So it's 6-1/2 dozen either whether we take a position right now or tomorrow morning. Should we take a position on this while it's all fresh in our minds, or would folks like a night to think about it?
We've lost.
I did talk to Representative Waters Evans. I think since this is just to concur, she'll have the opportunity to talk on the floor. So I think this time of year.
It's a straw poll anyway.
It's straw poll anyway. Yeah, it's not a recorded vote. So if I'm absent any objection, I think we should take a position now and get this thing on its way. All right. So all those in favor of concurring with the Senate proposal of amendment, please raise your hands. All right. So we got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So we'll do an 11-0-1 straw poll. Mr. Devlin, you have done great work on this bill. Thank you very much, sir.
Very well.
All right. Andrew, thank you.